Welcome scholars, this is Mr. Myers, lesson 3.7, Equal Protection Rights. As you can see, we have a lot of objectives to cover in this particular lesson. You're going to need to take good notes. A lot of the cases and the equal protection examples that you need to know are listed in text form on the screen. So take good structured notes and let's begin. The concept of equal protection of the laws was guaranteed by the 14th Amendment, so this has its historical origins in the Civil War and Reconstruction. The basic meaning is that equal protection establishes equality before the law and guarantees fair treatment regardless of sex, race, or national origin, religion, or political views. It guarantees this idea of an equal starting point, equality of opportunity, as opposed to an equal ending point, which is equality of condition. So the idea is that the 14th Amendment allows us to start with an even playing field in terms of those protections, but doesn't guarantee an outcome that we will all be necessarily equal. Now, just because the federal government guarantees equal protection under the laws doesn't necessarily mean that they can't classify, or in some cases, you could even say discriminate against certain classes of people. Sometimes the state has a legitimate reason to classify people. The best example here would be driver's license age laws. As we learned from McLovin over here on the right, you need to be a certain age in order to be able to drive a motor vehicle. So we classify people that way. We have three levels of analysis on whether or not classification laws violate equal protection. And the three levels are strict scrutiny, intermediate scrutiny, and rational basis. Now, this is the most confusing part of this particular lecture, so you're going to want to probably pause and copy down this chart, and then start it up again and I'll explain it. So what we have here is three different kind of classifications or levels of scrutiny on when the federal government can classify people. And the basic idea here is that when you classify by age, it's easier to do, and the state is likely to get away with that. It says at the bottom that the law is presumed to be constitutional unless proven to be irrational. I think most of us would agree that it's not irrational to prohibit 7-year-olds from driving an automobile, right? So discriminating by age, or classifying rather by age, is something that has a relatively low degree of scrutiny from the government. So those laws have a rational basis then for their existence. This next classification level of intermediate means that it's getting a little bit more difficult for the state to classify, and the burden of proof is going to be higher on the government. So if you were to classify by gender, by male or female, that means that the government might become under more scrutiny, that law might get looked at more carefully by the courts. In this case, the state must show the law is substantially related to an important purpose. It gets harder to pass laws that classify by gender or sexual orientation. So another example might be serving in the military. Again, it's rational to understand that we would prohibit minors, young people, from serving in the military and carrying guns. But what about women? So as you talk about denying women access to military jobs or combat roles in the military, again, that level of scrutiny becomes a little bit tighter. And of course, recently women have been allowed into combat roles in the military. The last level of strict scrutiny means that the federal government must have a major serious reason to classify people by race or ethnicity or national origin. The state must show the law is needed for some major compelling state interest, and it's almost always in the interest of national security. So to summarize, it's easiest to classify people by age. It gets a little bit more difficult when you're classifying people by gender or sexual orientation, and it becomes really difficult to classify people by race or national origin. As you move down that spectrum, it gets harder and harder for the state to prove that it has a compelling reason to classify people in this particular way. Again, this can be pretty confusing, so if you have any questions about it, make sure you bring it to class tomorrow. So what we have here is a chronological list of major equal protection cases that you need to be familiar with. You probably should pause this, jot down the titles of each of these cases, and then I'll explain each briefly. Okay, so the first major case that you need to be familiar with is Korematsu v. U.S. During World War II, FDR and the federal government rounded up Japanese Americans, especially on the West Coast, because they were worried about espionage and national security threats. And in this particular Supreme Court case, that action was upheld, that the right to classify people based on national origin was indeed rooted in a national security purpose, and therefore Korematsu's rights were not violated. Most of you are familiar with Brown v. Board of Education of 1954. This overturned the famous Plessy v. Ferguson case of 1896, I think, which basically allowed separate but equal to rule in schools, and this basically overturned that doctrine and said that no, you can't discriminate, you can't segregate black and white students in schools. Now, the Civil Rights Act of 1964 furthered that idea and basically said not only can you not discriminate in schools, you can't discriminate in any public spaces, whether that's libraries or swimming pools or whatever the case might be. And please note that this not only includes race, but national origin and sex and religion as well. The 24th Amendment banned poll taxes, which often discriminated against poor people and African Americans and denied them equal access to the ballot. The Civil Rights Act of 1965, also called the Voting Rights Act of 1965, banned racial discrimination in voting, banned literacy tests, and sent federal registrars to the South to make sure that states that had a history of segregation were not discriminating against people in order to deny them the right to vote. And Loving v. Virginia in 1967 struck down interracial marriage bans. Bowers v. Hardwick criminalized homosexual activity. Lawrence v. Texas overturned that, very much like Brown overturned Plessy. Lawrence v. Texas overturned Bowers v. Hardwick and basically said that laws that discriminate against homosexual practices are unconstitutional. And Obergefell v. Hodges in 2015 legalized gay marriage. Now, a major concept you need to be familiar with is affirmative action. This is when you give preference in employment, hiring decisions, and in education admission decisions to groups that have historically been denied equal opportunities. In this particular case, you're almost always talking about African Americans, but minorities in general. Women could also be included under affirmative action. Now, Regents v. Bakke is the major landmark affirmative action case you need to be familiar with. In 1978, this case basically said that schools can use race as one factor, not the factor, but one factor in college admissions decisions. However, there have been a multitude of cases that have come down that have ruled on particular aspects or parts of affirmative actions, and so depending on how much of a factor race is used in these decisions and a whole host of other factors, we're really kind of unsure where the future of affirmative action is heading. So instead of giving you all the cases that deal with affirmative action, know the landmark one, Regents v. Bakke, and then understand that the future of this is relatively unclear. Opponents of affirmative action basically argue that this is reverse discrimination, that you're using race to determine whether or not to allow someone to have a job or to get into college. Here are our objectives again. Hope you took good notes. Be ready for a quiz tomorrow and have a great day.